Hello, everyone. Warmly welcome to this LawTransform webinar, which marks the World Water Day and invites to discuss how the recognition of the right to water as an independent human right actually makes a difference to marginalized people's claim for water. This webinar is held by LawTransform in collaboration with Bergen Global and the Center for Policy Research in Delhi. LawTransform is a global research center based in Bergen. It was established in 2014 as a collaboration between the Flint Michigan Institute and the University of Bergen. Through international interdisciplinary research collaboration, teaching, and dialogue we are having today, LawTransform aims to understand how rights and law are used as tools for social change and to what effect. My name is Giedrė Čosaitė. I am representing LawTransform and giving to you a short introduction to the panel we are having today. Today's discussion draws on ongoing work from the LawTransform research project Elevating Water Rights to Human Rights, which is funded by the Norwegian Research Council and is led by Bruce Wilson from the University of Central Florida and CMI. This project is a collaboration with LawTransform fellows in a number of institutions, and the panelists you are meeting today, they all are working on this project and are all long-term LawTransform collaborators and affiliates. Water Rights Project aims to look at the impact of the human right to water. The project comes to an end this year, and currently project team is working on a book edited by Bruce Wilson, Daniel Brings, and Arkaya Sin. We are happy to have Arkaya Sin moderating our discussion today. Arkaya is a fellow at the Center for Policy Research in Delhi and also a part of the State Capacity Initiative. We also have her colleague from the Center for Policy Research, Namita Vahi, who is also a founding director of the Land Rights Initiative. Jackie Dugard is joining us from the South Africa. Jackie is an associate professor in the School of Law at Wits University in Johannesburg. Jackie is also an associated senior researcher at the Flint Michigan Institute. Rebecca Scheel is joining us from the United States, where she is a postdoctoral researcher at the University of Central Florida. We also have Angela Murcia, an assistant professor at the Department of Public Administration, Tennessee State University. Welcome all. Thank you for being with us today. And before giving a word to Arkaya, I would kindly mention that audience is welcome to ask questions in the Q&A section. Arkaya, the floor is yours and you're welcome to start the discussion.
Thank you, Giedrė, and we're, welcome to my panelists and all of us. I'm very happy to be having this conversation today. So we're a decade now from the formal recognition of the right to water in international law. And at this point, we consider for our project and for the book, the idea that global rights as socio-legal constructions emerge from, not just from the work of international legal actors, but from a loosely connected and decentered process of appropriation and deployment of the language of rights in various political struggles. In this process, formal norm creation interacts with discursive and political deployments of the language of rights in sites of contestation and in mobilizations in a variety of contexts. The right to water is often in popular literature and in the press. It's something that has gained prominence contemporaneously with the neoliberal reorganization of state-society economy relations. And with this, the water sector reforms that accompany this type of reorganization, a paradigm which is sometimes referred to as water governance. These reforms could result in shifts in service provision and pricing models of water services, and the resultant and very real fear of exclusions and disconnections. This is sometimes the context in which mobilizations around the right to water emerge. And in this, the formal adoption of the right to water could be driven by the idea of subsuming the discontent. It could be a way of depoliticizing various types of unruly claims, but this is just one version. This is just, illustrative of the process of the construction of rights. But let's stay with this for a moment and consider what are the correlations and connections between water and governance, and what happens if you think of the right to water as infrastructure, by which I mean the infrastructure for water extraction, treatment, and supply, and of course, in having the processes and systems to manage this infrastructure. Rebecca, from your work, what I can see is that I'm going to ask Rebecca to talk from her ongoing work about the right to water. And what I can see from this work is that having the means, the capacity, and the structures and systems for infrastructure seems to make a bigger difference to access than the formal recognition of rights. But in this process, the democratic process and the rule of law also seems to make a difference. Could you explain this, Rebecca?
Sure. So in the ongoing research that I'm doing with Dr. Bruce Wilson and Dr. Malcolm Langford, we look at several different political determinants of water access. We look at resources, for instance, renewable water, and then we also examine things like regime type, so democracy, anocracy, autocracy, and we look at development, so GDP per capita, and then we also look at different measures of democratic governance, which in this case includes respect for the rule of law. In earlier research, we found that rights on their own didn't seem to have a statistically significant correlation with water access. But when these rights were foregrounded in democratic governance, meaning respect for the rule of law as one of the measures, that we did see a positive effect of having a constitutionalized right to water, or maybe just a greater rights environment, meaning a greater number of social, cultural, and economic rights within a state. In this research, what we're interested in is whether the positive correlations between things like development, democratic governance, regime type, and renewable water are conditional, whether they operate on their own, or whether, like democratic governance, a foregrounding in the context of higher levels of economic development make a difference. And what we find is that while there are correlations between things like renewable water and democratic governance on their own, once we control for economic development, these statistical associations tend to disappear. And the same thing goes for rights. So what that tells us is that rights might have a positive impact, but more importantly than just the constitutionalization of rights is the context in which they take place. So you need the right level of development and you need democratic governance in order for these rights to be as effective as they're intended to be.
Thanks for that, Rebecca. But this makes rights, but rights are no less significant because of the fact that the formal recognition of rights doesn't seem to matter, or perhaps people are having different conversations in different places. Angela and her co-authors have been working on have been looking at the process of the successful and unsuccessful, variously, of constitutionalization of rights in South America. They found that it was successful in Peru, but not so successful in Brazil and not so successful in Brazil and Colombia. But Angela, could you talk about the nature of the contestation? Why were people, what were the rights people were fighting for? Where were the battle lines drawn? And what was the larger context in these countries around which the mobilization for constitutionalization of rights happened? Why, which could help us understand why it might have worked in some places and didn't work in other places, although its success or failure is obviously not the only issue, but a way of understanding where those contestations are.
Absolutely. Can I ask you to, I want to turn on my camera, but it says like the host, I need a permit from somebody to turn on my camera.
Yeah, that's me.
Thank you. I can start talking because I know that we have some time limitations. So thank you so much for inviting me to this panel. And I want to refer to the paper that Arcadia mentioned that I'm writing with Camila Janela, Lara Cortez, Catalina Vallejo, and myself, where we're comparing experiences of constitutional reforms to enshrine the right to water in Brazil, Colombia, and Peru. And Arcadia summarized it really clearly that what caught our attention and wanted to explore this topic is that Peru was successful at passing a constitutional reform in 2017, while Brazil and Colombia have not had the same success. And the question, of course, was why, considering that the three countries have quite a few similarities when it comes to, water rights or right to access to water. Not only geographical proximity, right? The three countries share space of the Amazon rainforest, but also from a kind of challenges perspective, the three countries, are facing deforestation, like land conflicts, industrial exploitation of land, particularly mining, or agriculture, right? So if you put that in addition to the limitations of governments or governments being ineffective to provide water rights that lead to deep inequalities that are particularly affecting rural communities and native populations as well, right? So we thought it was worth exploring these commonalities and differences. And as you mentioned, Arkaja, our belief is that the constitutional reforms, whether they're successful or not, is a consequence of the legal environment in these countries. And I was just going to go ahead and highlight the themes that we found, and I'll be happy to expand some more in the Q&A. And I would love to share some examples of what Arkaja was asking, like in terms of, oops, start my video. Hello. As I was saying, I'll be happy to share with you in the Q&A some of this data that we have found in terms of like legal mobilization, what people are asking, what they want when it comes to water rights. But let me summarize the themes that we found. So in Peru, what we see, or this is all a matter of political cost in the three cases that were explored. In Peru, the constitutional reform of 2017 was initiated and promoted by congressional elites. And it was less costly for them to pass the reform than not. It seemed like what they caught in the air is like a change in the environment, so they needed to be kind of up to par with international regulations. And what they did is they passed a constitutional reform that was not very ambitious. I mean, it did enshrine the right to water, but it just kind of repeated what was already in the legislation. And it seems like there's some skepticism in Peru of what this reform would imply for the people. And I will expand on that later if that's of interest to the panel. Now, in the case of Brazil and Colombia, the political cost situation is very, very different. So in Brazil, what we're seeing is a combination of federalism and privatization. That's another key theme in Brazil. So when I say federalism is localities are the ones who are responsible for providing access to water. But the federal government is very interested in fostering, encouraging, more participation of private parties in water provision. To do so, the federal government has wanted to pass some standard kind of regulations when it comes to water quality, but there's strong pushback from the community, from unions, from native populations and academia and so on, kind of pushing against privatization. And this tension has led or has been brought to Congress. Brazil has seen 5 different attempts to reform the constitution, the most recent one in 2018, but it was kind of a superficial type of attempt from the perspective of it referred to the right to water, but there was no content to the right and did not touch privatization. So you can see that it's not kind of touching that main theme that we're seeing in the country. Now, finally, the case of Colombia. What we're seeing here is a vibrant kind of bottom-up push for a regulation that would kind of adapt better to social needs in the country. Deep inequalities, rural areas do not have water provision from the country, and I'll be happy to expand on this later. But when these initiatives meet or get to Congress, they get to be filtered. The political cost there comes from 2 sources. One, the government has been very clear saying if we pass constitutional reform, we're not gonna be able to afford this. We don't have the money to bring water to the rural communities and so on. Furthermore, litigation is going to break the country. And the second one is the second push comes from lobbying, like strong lobbying from private firms that are getting profit out of mining particularly. And again, I'll be happy to share some more kind of specific data from interviews that we have gathered. Yeah.
So, which brings us back to this, this sort of thing, one aspect of the right to water, which is water is infrastructure. So, the struggle in Colombia around around provision. So there was a real contest, a real sort of battle of ideologies about the role of the state in provision, and what claim of infrastructure, what claim to state resources do people have. But there is also a less radical version of rights, which is where recognitions are possible, but it doesn't necessarily reflect the recognition itself doesn't necessarily reflect a very significant transformation underlying that. Turning now to a related theme, which is the process of judicial recognition, the process of going to courts and talking, and the process of going to courts and what happens in the courts with the right to water. Namita and her colleagues have been doing some very interesting comparative work about varying judicial recognitions of the right to water in Costa Rica, Brazil, and India. And there are various ways in which people have mobilized the judicial process. Of course, this variety has to do a lot, with the structure of the court and with the opportunity structures. But there's also some running. There are also some running threads in this. The use of the domestic legal, the precise domestic legal framework around water services, and in other places, the mobilization of constitutionally recognized rights and the international human rights framework. And perhaps underlying all of this, the mobilization of administrative law in the deploying administrative law to seek judicial recognition of rights. There are also a range of disputes around licensing and regulation, which again reflect contextually the governance of water in the places where these disputes have emerged. However, there is also the possibility of thinking about, so sometimes the choice of this framings depends on whether it's a claim for water as a service. Some, jurisprudence which is much more developed in Costa Rica and Brazil and not so much in India. There are also in all of these places claims over the use of the rights language of water to make claims over water as a natural resource, as property, and sometimes to seek its protection in environmental law. But there's also a more capacious, a broader idea of rights as claims for social justice. In the conversation in India, around this particular, World Water Day is not so much about water as a service, but the access to water and caste discrimination. We are, it's almost 100 years from the sort of what's traced back as the origin point of Dalit mobilization around the right to access water, public water from places from which they were formerly excluded, what's called the Mahar Satyagraha. Namita, in this, in this context, would you like to talk a bit about the multiple and variable and interconnected meanings of these framings, and what this means for the potential, and what potential there is for framing the right to water as social justice?
Sure. Good evening, everyone. Thank you, Gedra and the Center for Law and Social Transformation for organizing this very important webinar on a very important day when we are celebrating the World Water Day. Thank you, Arkaja, for organizing the panel, and to all my fellow panelists. It's been such a wonderful experience working on this book project with all of you. I've learned so much. I think to start with, I just want to acknowledge the fact that today is World Water Day. And I think that, unfortunately, we tend to celebrate days for things where there are social justice, dimensions to it. Otherwise, it never gets its day, so to speak. And so, I think the very fact that water is a scarce resource today, is under enormous pressure, and is something for which there are claims regarding social justice, is I think why we are actually celebrating this World Water Day. And I think water is so basic to human life. We know that human beings can live for like over 20 days without food, but we cannot even survive 3 or 4 days without water. So it is that basic to human life. So the right to water is inextricably linked to the right to life conceptually. And insofar as most countries that have democratic constitutions do in fact recognize the right to life implicitly, there is a recognition of the right to water. But legally, this correlation has been made only, in the late 1970s onwards, and internationally as a human right is a much more recent thing. So it is not surprising, and I've been working on this chapter with my colleagues Lara Cortez, Ana Cortez, and Evelyn Villarreal. And we looked at how the right to water has been articulated in the context of Costa Rica, Brazil, and India. 3 countries that are all democratic constitutional republics, but are quite different in many ways. Brazil and India are 2 of the largest countries in the world by landmass, and also in terms of population. Brazil is the 5th largest country in the world. India is the 7th largest. And the difference being that Brazil also has abundant water resources whereas in the case of India, we are home to over 1 billion people, but we have 18% of the world's population, but only 4% of the world's resources. On the other hand, Costa Rica is a smaller country and is more sort of economically developed and has been able to provide, clean access to clean water. It is one of only 2 Latin American countries that has actually provided clean drinking water to its population. So, when we talk about rights, rights are somewhat abstract entities, and they only acquire meaning in particular economic, social, and political contexts in particular periods of time in history. So, this context perhaps sets the basis for how the right to water has been articulated in different ways in these countries. The second thing, of course, is what Arkaja mentioned, is the legal opportunity structure. All these countries recognize the right to life. They also recognize social and economic rights, but these rights are expressed in the case of Costa Rica and are more sort of impliedly justiciable or have been read into justiciability in the other 2 contexts. And in all of these countries, the right to water has come out of either the right to life or the right to a healthy environment, in relation to what Arkaja was also mentioning, the right to preserve natural resources in their pristine purity as part of a healthy environment. So these are some of the common features that have emerged in terms of the articulation of these rights. But because Costa Rica already had a water governance law in the 1940s, it has 18 administrative agencies that are, entrusted with the administration and provision of water. Therefore, there is, and because it is a country where you have direct access to the constitutional court, as opposed to India and Brazil, which have a federal judiciary. Of course, in India, the judiciary is a unified judiciary, as in we have state high courts, but it's one judiciary. In Brazil, we also have state judiciary as well as the federal judiciary, and each of these courts have different powers, and they hear all kinds of cases, not just constitutional matters but legal matters. So the legal opportunity structure in Costa Rica as opposed to India and Brazil is quite different, and what that means is that there are a lot more claims that have been brought before the Costa Rican court, also because there are a lot more statutory rights that people have in order to make those claims, as opposed to, say, in Brazil and in India. One of the key differences that we find in terms of the general framing of the right to water is, as Arkaja mentioned, in Costa Rica, there is a lot of there's a lot of claiming as the provision of a service, and that's because water in their constitution has been defined as a public good.
And whereas, also because the service is better developed, because yes, as a matter of fact, it's a richer country which is able to provide water rights as infrastructure. It's able to provide clean and well managed water services to a much larger percentage of its population, which suggests that there is a sort of legal institutional frame, a stronger legal institutional framework around water as a service, which is perhaps reflected somewhere in.
Yes.
So go on.
Whereas in the case of India and Brazil, we don't have such an express framing, and therefore there are many diverse framings of the right to water. One particular difference between India and the other countries is the right to water because it has emerged out of common law principles as during the colonial period. Therefore, it is actually a right which includes the right to livelihood. A lot of water claims are for actually irrigation, as well as access to water for drinking, as well as for irrigation or easementary rights to access water for cultivation. And so that's one key difference that comes out. The other framing that Arkaja you mentioned was about as water as a social justice claim. And here we find in the Indian context, as you mentioned, we have an express right in the Constitution, Article 17, which prohibits this practice of untouchability, according to which, Dalits were discriminated against in various ways within the framework of Hindu society, and they were not allowed access to the same drinking water. And there's a criminalization of denial of drinking water to Dalits as per the Untouchability Offences Act. Now, what we see is that we do have some criminal prosecutions that have been brought by Dalits, because there's hugely unequal access to water between Dalits who are 16% of India's population, but only 28% of Dalits actually have access to water within the premises. So that is one framing on behalf of a marginalized group. The other framing is on behalf of Adivasis or indigenous communities. We see this framing both in India and Brazil, where we have this concept of Jal Jangal Zameen, which means that water, land, and forest. And what that framing means is, but in this framing, water and land are not separate. They are seen as part of a larger ecosystem. And within that ecosystem, there is this claiming, because Adivasi groups are the ones who are disproportionately bearing the burden of economic development. And so we have people who have been displaced by dams and other projects that are actually, been created to meet the requirement of providing drinking water to the general population, but they are disproportionately impacting the drinking water of the people who lived in those places, because they have been displaced and they have been moved to places where they don't have drinking water, or their water sources have been polluted by industrial growth, which is justified as being necessary for economic development. So those are some of those framings, but we don't see, and those framings are very widespread, but we don't see those framings necessarily receiving a lot of judicial recognition. There are the odd cases which say that once they are displaced, they should be provided drinking water like the rest of the population, but not recognizing their intrinsic right to the ecosystem where land and water are connected and not separate.
Which is perhaps, perhaps now, time to move to, the contrasting version, which is, the very specific form, the very specific, but legally defined form of the right to water in South Africa. And perhaps a good time to, for Jackie to talk about the Day Zero in Cape Town, because it brings us to another type of contestation, a very sort of interesting one, something that, is perhaps tells us something about the right to water in the future. And Jackie, over to you to tell us what happened in Day Zero, and how did the right to water fare in the moment of Day Zero in Cape Town.
Thanks very much, Akarja, and thanks also to Giedre and to everybody for organizing the webinar. So Day Zero, the reason that I became so interested in looking at this was that South Africa is quite renowned for being one of the first countries to constitutionalize a right to water. And this is obviously because in 1994, there was a general move to democratic change in South Africa, during which socioeconomic rights, including the right to water, were recognized. So we explicitly have a right to water in the Constitution. We only ratified the International Covenant on Economic, Social, and Cultural Rights quite a few years later. So for us, the domestic right has always been this sort of framing right for many years prior to the international right. But what I find so extraordinary is that despite the fact that we have a right to water in the Constitution, and despite the fact that we've also ratified the International Covenant, and so therefore also recognize the international rights, there's been very little explicit water rights contestation in South Africa. Indeed, there's only been one water rights case that's come before the Constitutional Court, and it stands out for being one of the very few Constitutional Court cases dealing with socioeconomic rights where the applicants lost on all grounds. So there is so much of interest here, I think, to try to unpack. And so in trying to unpack this puzzle, I decided to look at a clear case of a water problem to see how it was experienced and framed by the people that went through it. And between 2017 and 2018, the city of Cape Town was threatening to become the world's first metropolitan city that was going to run out of water. And this was termed Day Zero. And it was actually very explicitly in the public domain, in the media, by the city of Cape Town, a countdown to Day Zero, which was going to be the 7th of March, 2018. And in the run up to this Day Zero, the city of Cape Town attempted by all means to restrict water. And at first it was voluntary, and then it became compulsory. And the final sort of compulsory regime was limiting all households to 50 liters of water per person per day. And in fact, the city of Cape Town rolled out water management devices if you exceeded that amount, which would then physically limit that supply. And indeed, through these measures, the city of Cape Town actually became the first city in the world to drastically reduce its consumption of water by 50% within 1 year. A few years earlier, the city of Melbourne in Australia had managed to do this, but it took them 12 years to achieve this. So in fact, the city of Cape Town won an award for this. So the questions, long story short.
In a sense, a victory for water governance and
yes,
for them, a managerial victory.
That's right, and effectively, day zero was averted. It still remains. Cape Town remains a water scarce city, and that threat looms. But the issues that my research were looking at very briefly were really how were people framing this? And what was completely striking is that nobody was framing this or explaining it as a water rights issue. So then I was curious, what are they framing and explaining it as? And we spoke to people from informal settlements, we spoke to people from NGOs, social justice and environmental NGOs, and we spoke to richer residents as well. And strikingly, nobody saw this as a water rights issue. They all saw it as either a water equity and justice issue or a governance issue. And so on the justice and equity axis, many people pointed out that now rich people for the first time were being limited to the same amount of water that poor people are limited to because of their inability to pay more than the free basic water amount, which is 50 liters per person per day. So already poor people had water management devices which restricted them to that amount because of their inability to pay for anything more. So they found this actually a very positive thing, that everybody was now in the same boat. So they were seeing that they saw no reason to evoke human rights because they actually saw this as being about justice. Finally, everybody was in the same boat. And actually, interestingly enough, richer people also, I think, saw the equity in the situation. And there was perhaps something that everybody was feeling, we are all in the same boat. There was a lot of discussion about governance. Many people were saying that there was wrangling between a decentralized neoliberal system and wrangling between national government, provincial government, and local government. And very briefly, what do I think one can make of all of this? I think one doesn't, and as other speakers have said, this isn't to suggest that the right to water is not useful. It's not to suggest that a domestic right or an international right, just because it hasn't been explicitly evoked, is not useful. It may be at certain points and in certain contexts, and you've heard from other speakers where that is the case. But in South Africa, it just happens to be that there are other issues or hooks that people use more readily. So for example, issues around access are often dealt with through infrastructure type of questions and rights, such as the right to housing. And issues of quality are often dealt with through environmental rights and pollution related issues. But the one issue that this has made me think about, and I think that the day zero crisis might make us all perhaps reflect on, and in terms of the iterative process between international and local, from a bottom-up perspective, I think the Cape Town day zero crisis might tell us that perhaps going forward in the world, which is becoming more unequal, more water scarce, we might have to consider the justice framework primarily. And what do I mean by that? We may have to say, however much you can afford to pay for water, it's not fair, it's not acceptable. Everybody should only be able to have the same amount. And that is because the very specific nature of the right to water, unlike any other socioeconomic rights other than land, is a finite resource. And perhaps going forward collectively, we will have to think about this in the international arena, that this is the one right that, or one of maybe several, including land, that really does need to be thought of through an equity and therefore governance frame. Thank you.
So when the right to, thank you so much for that, Jackie. So when the right to water was formulated in the international law, the 2010 resolution, it didn't make a reference to the natural resource. It didn't make a reference to scarcity, and there was an implicit assumption that an economic pricing model. I mean, there is an implicit assumption in some versions of the right to water that an economic pricing model is just if it is balanced with some form of basic access for people who can't afford the economic price. And in a sense, this the moment of day zero points out the limits of that thinking. Points us to the limits of that thinking, and points us to the limits of the right to water as infrastructure. And the right to water as infrastructure is hugely significant, hugely important. It's it's how drinking water is provided, to people who can't access it directly from rivers and wells, and it's therefore there's no denying its significance, but that's not enough. And in that, maybe you could also tell us a little bit about the history of how the right to water in South Africa came to be formulated in this particular way.
Well, just very quickly onto your first point, I think that's such a good point that, you know, as much as we want to ensure that there is cross subsidy and that perhaps richer people might cross subsidize poorer people, which is what currently happens in South Africa with rising block tariffs, we may have to think beyond that because of the scarcity issue. And so I really do think we're going to have to start thinking of a different paradigm. Onto just briefly about the history. You know, South Africa obviously has a specific history regarding all of its socioeconomic rights. The right to water is really no different from any of the other socioeconomic rights. They're a product of a negotiated settlement between the liberation movements and the apartheid regime. And it was very clear for the liberation movements and their supporters that socioeconomic rights had to be entrenched because apartheid was not only a system of civil and political exclusion and domination, but also socioeconomic. So the right to water was absolutely one of the key rights that was entrenched in 1994 and in what we call the final constitution of 1996.
So I had a question for Jackie, and my question is a bit connected to the conversation that's gone on during the process of the book writing. And it's the question about rights efficacy and how we judge the efficacy of rights, I guess, when we consider that rights are often relied on in the context where they're needed most and where there is the least likelihood that anything else can be mobilized by people who need water. So I would ask Jackie if she thinks that that is the case in South Africa, and that's why rights were relied upon rather than some sort of other mobilization, for instance, for improvements in democratic governance.
Thanks. Should I answer?
Yes, Jackie, I'm sorry I got signed out briefly, but I'm back. And
sure.
yes, please.
Thanks, Rebecca. I think it's a very good question. And, you know, with all the skepticism of rights, I think it's always so important to compare with other strategies. And it is harder and harder, I think, with rights kind of diffusing, and I see this as a positive thing, diffusing across a lot of social and political realms. It's hard actually to see what a counter strategy would be. But I think you can say that perhaps pure politics with a capital P, although based on the right, you know, to have political expression, and often based also on the right of freedom of association and of movement and expression, you can say that maybe that's a counter strategy that one should compare it with. And certainly in South Africa, things like direct political mobilization, for example, voting, really hasn't worked. And I think around the world we're seeing this, that there are huge problems with democratic politics, and it's not reflecting, or it's not getting a social justice outcome. So there's that. There's also the usual sorts of things such as petitions, lobbying political leaders, etc. And that's just, people are not really getting much traction there either. Protests, and this we've talked about in the book, is this a right strategy or isn't it? And I would argue it is, because it's largely based on the right to protest. Of course, the minute it turns out to be a violent protest, then you lose the rights, the legal kind of umbrella for it. But in South Africa, there have been quite a lot of protests around not the right to water per se, but municipal services and municipal governance. So again, it's not really about the right to water, but it's, you know, I just want to underscore that I think that it's not really that important which precise rights is engaged. I think it's a network of reinforcing rights. And I think that it is important to compare rights claims versus counterclaims. And I would say that in South Africa, the rights claims are more dominant, mainly because the political sphere, we've ended up with a one-party state, and the political sphere is not very responsive. Thanks.
I just wanted to put, put another aspect to this, which is the mobilization in Peru, where the mobilization in Peru, where it seems to have been constitutionally recognized, and and in places where it didn't work. Angela, could you give us a sense of the type of protest? What sort of street mobilization, or what sorts of other mobilizations were there behind the efforts to constitutionalize rights, whether they worked or they didn't?
Yes, thank you so much, Arkaja. And I wanted to connect to what Jackie was saying. In this paper, what we found is we kind of noticed two things. One thing is kind of the mobilization that is taking place in this country, particularly you asked about Peru, and kind of the expression of what people need, right? Versus, or in comparison to the constitutional reforms. What I'm saying is that not in all cases, this constitutional reforms have been led or pushed by social mobilization. That was the case of Peru in 2017. This was led, promoted by elites. And once the 2017 reform passed, we didn't see, or the country didn't see kind of big mobilizations in support of what this meant, right? So we see a disconnection there. And let me add this, and I know that goes beyond what you were asking, affirming that idea of one thing is what the language of the law, right, connects to water rights versus what like social mobilization or what the people actually needing. What we see in Colombia, and we have very interesting data showing that in rural areas, people kind of got tired of waiting for the government to bring water to them. So they developed their own systems, community run plants, right, kind of bringing in the water from the river, using their own water, like little water pipes. They don't have, of course, the same system of billing. They don't have, there's all about like trust and accountability. You cannot pay them this month, that's fine, we'll wait for next month for you to pay. So in that scenario, when you talk to community leaders, they don't want governmental intervention. They're pushing away from, they use the language of rights. When do they get used, or when do they use the language of rights? Recently, they've started kind of being interested in legislation, but to protect them, to try and get that kind of neoliberal approach, like privatization and type of service provision that is kind of predominant in the country, away from them as much as they can.
Namita, you wanted to say something also?
Yeah, in response to what Rebecca asked, because I think, your research, Rebecca, is so interesting and sort of foregrounds the question that you've posed. I think, and I don't know if perhaps Jackie would agree with me on this or may have other thoughts, but the way I understand the rights discourse is that it's a dignitarian discourse. Insofar as it sort of recognizes the individual dignity of every person. And the difference between, and of course, rights are no magic bullet. They not necessarily translate into the outcomes that you're looking for. But I think the key difference between a governance framework versus a rights framework, because this is not something that we are seeing only in the context of water. We are seeing the governance versus rights debate even in the context of land, in the context of other, rights and resources that we have. I think the key difference is the social justice claiming that Arkaja adverted to when she asked me the question, because what happens is that even if you can have that kind of political mobilization and that provisioning, it's always the case that, the elites, both in terms of economic elites, but also social elites. And in the context of India, where discrimination is so rampant and a part of Indian society, and it's not just caste discrimination. We had an incident recently where a Muslim youth was beaten up for trying to take water from a Hindu temple. So that kind of social discrimination, which is very much prevalent. How do you address that from a water governance point of view? You could provide water to a village, but if they, if they decide to discriminate in terms of access to that water amongst social groups, then what is the claiming that you can have? And I think our constitution is unique in the sense that it was drafted, the chief architect of this was from a historically marginalized community, from the Dalit community, Dr. B.R. Ambedkar. And I think that's why the constitution has this very firm commitment to anti-discrimination within the text of the constitution, and specifically mentions access to bathing ghats and wells as one of the things that has historically these communities have been deprived of, and that has to be provided as a matter of human right that sort of exists in terms of its moral compass. It sort of exists outside of the constitution as well. And I think that's the key difference, is that in issues of scarcity, in issues of discrimination, in issues of and discrimination can be various factors, the rights language has a certain moral claiming which is stronger than the governance claiming. But of course, that doesn't mean that it's kind of a necessary claiming, but it's not sufficient for, just because you have a human right doesn't mean that you'll actually have it translated. What that content means is very different in different contexts. And which is why what we found in our chapter was that, the international recognition of the right to water has come much later than the way it has been articulated and framed in these countries. And at least in the case of India and Brazil, there's very little reference to the international framing.
But what happens when what happens when the recognition of a right or a particular framing of a right, what happens with, when people, you point to this, you point to this in what you've said, but multiple kinds of vulnerability that people face. And one of the, what I'm looking at in my work is the fear of eviction and how this is, the people in insecure housing and how this is linked to the right to water, and why the right to water is not a claim that they make, because it might make, there's a very strong and likely risk of, drawing attention to themselves in ways that perhaps make them more vulnerable. And this is something Angela and I talked about previously as well, because this is this is the big fault line in urban settlements around access to water. It's you see it across countries, you see it across where rights matter, and where the dominant framing of rights may actually not be enough to address the type of fault line that this is, because it is linked to the particular forms in which claims over land are recognized or or not recognized, and how this undermines, and so the rights are interconnected. And so a right to water means nothing if it's framed in a way that keeps you continuously insecure.
Yeah, no, I completely agree with you. I think that even as I say that human rights has a discourse, has a dignitarian value to it, I don't mean to reify rights in any ways. And, rights are abstract. Rights conflict with each other. Rights of certain groups will matter more if they come into conflict. I mean, these are sort of the lived realities of in rights enforcement. But I think that that's why it may not be even necessary. Maybe you could achieve those same goals otherwise. But oftentimes that rights language can push the needle on something where you don't actually have been able to, through political mobilization, been able to pass laws securing those rights or not. I mean, the very fact that some of these cases have come about through a jurisprudence of exasperation on the part of the Supreme Court, because there was a rampant pollution of water resources and there isn't enough action by state administrative agencies to actually protect that. The fact that the Constitution gave a right to life and a right to healthy environment is how the right could be read into it. So it's just a tool, and tools can be deployed in various ways. But I think it's an important tool, and I think it's important because in the whole development versus rights conflict, the development discourse is a utilitarian discourse. It's the greatest good of the greatest number. And I think the human rights discourse is a dignitarian discourse, which focuses on each individual as being important. So yes, if from a development point of view, pushing an Adivasi population, which is like 8% of India's population, provide drinking water to the remaining 80%, makes sense because it's a utilitarian calculation. But the incalculable misery and suffering that indigenous communities have experienced all over the world, the very fact that, even though Adivasis are 8% of the population, they are 40% of the people who have been displaced since independence, so that kind of disproportionate burden that certain groups face can only be alleviated through through espousing their claims in the language of rights, where each individual matters, and not just, and I think it's particularly important in developing countries where development is reified. Like everything seems to be justified for development. And I think that's why even in the case of Costa Rica, which has, the income and the provision of water, one of the things that, Evelyn notes in her section is the fact that, recent events, urbanization, economic development, these are what is putting pressure on the right to water, whereas earlier they did have this basic provisioning. So I think that's where rights language matters.
Be slightly contrarian. There are two possible ways of being contrarian. And one of these is, what does the incoherent recognition of rights mean? Often so you haven't sort of distinguished that, you don't distinguish that much between what sort of remedy. So when the court, when judicial recognition, when it recognizes the constitutional right, or it recognizes the right in international law, versus when it recognizes the right in administrative law or in specific water regulation laws, what is the hierarchy of remedy? What does it really give to, what does it really give to people is something to bear in mind in possible sort of alternative framings. This is one thing. And the other thing is to think about the subsuming of rights or demands or claims of the state into programs and schemes, and the reluctance of rights. I mean, there's the role of rights, and there is a question about holding states accountable, and it's states naturally don't want to be held accountable. They would much rather say here's a huge big government program that is going to definitely expand access over a period of time, and is definitely going to over a long period of time reflect improvements in aggregate national figures of safe and basic and safe water access. But what does this mean in social and economic, this sort of social and economic entitlement expansion is often associated with non-democratic impulses in government. There is the fear that you be happy because I'm going to give you all of these things, and now so the interconnectedness of rights and freedom.
I think just to add to the question that I asked earlier.
Yeah.
Okay. I think it's really important to consider. So my initial question to Jackie was regarding, whether rights might be relied upon in the situations where they're needed most, and there isn't the opportunity, or there hasn't been a successful opportunity to mobilize around other things that might be just as important, for instance, development or democratic governance. And I think that, as we talk about rights efficacy, one really important thing to note is that, for instance, when you look at the states that voted affirmatively for the 2010 human right to water and sanitation, or if you look at the states that adopt a judicially enforceable right to water and sanitation, by and large, these are developing states. The human right to water wasn't, countries like the United States didn't vote for it, they didn't vote against it, but they were either absent or just didn't vote for it. So one of the things that's really important to point out is that in assessments of rights efficacy, you're working with a biased sample to begin with. You're already looking at the states that are in the worst positions related to clean water access and safe sanitation access. And when those are the states that are most likely to adopt these rights, they have the farthest to go in terms of progress. So when we just look at measures of, for instance, access to these things, and we make determinations about the efficacy of rights, it's probably not always the best way to then understand the true efficacy of rights as a whole. So we have to take that into account, that progress in a state that has very low levels of sanitation or water, for instance, might be a lot greater in a developing state when there is a right there that moves that process forward than, for instance, in places like the United States that don't have a right to water, that didn't vote for the UN human right to water and sanitation, that have large swaths of the population have access to clean water and safe sanitation, the vast majority. But then you have very difficult situations. Flint, Michigan is probably the most notable in the US, right? That doesn't mean that a right here couldn't be helpful. It's just that we're not looking at these countries because they already score so highly. So I think that's really important, and it ties back into what Namita was saying about, specific populations that are left out. While it's a small group of people within an area, they're the people who are most likely to have, rights or just basic fundamental human rights violated.
And can I briefly, sorry,
yeah,
I wanted to connect briefly to what Rebecca was saying and what you were saying before, if like whether communities use the term right to water or not doesn't mean that they don't have those claims or those needs, or they're not working through the system to achieve or to meet their needs, right? And let me share with you briefly one example. In our data collection interview with folks who work at Congress in Colombia, they kept referring to this case of the Páramo Santurban. It's just a páramo or like there's a lot of water, and that kind of the water for a big region comes from there. And big mining projects have tried to start there on and on, starting in 2009, filing petitions to acquire a license to do their mining projects there. Interestingly, it seems like, so once the petition was filed for the license, the head of the water plant in a nearby city, a large city, brought notice to the community. So it's the bureaucracy working with the community, and the community started mobilizing. Interestingly, when you look into the legal tools they use to push back against this project, yes, they talk about the right to water, but I mean, and they went to courts, sure, but they mostly mobilized towards bureaucracies. They tried to push away, saying, we're not taking seriously the environmental impact of this. And it connects to land rights and discussions, because here the issue is, how do we draw the line of protection around the mountain? Right? Because the answer of the mining company was like, we're protecting this area, everything is fine. They're like, no, you're restricting it to this area, but our communities are drinking from this wider area, right? So this is me saying, yes, there's a conversation on water rights here, but how the communities have learned the language of bureaucracies and pushed that way, right? And some litigation as well. But so this might not all have the best of water rights, but also connected to infrastructure, connected to water, to land rights, and so on. And this is also a claim for water from these communities.
Thank you, Angela. That's a super interesting example because it has everything. Jackie, you wanted to say something.
Great. Yes. Also to Rebecca's point, I mean, I think it's so important not to be too instrumental about rights. And it seems that actually the right to water may be one to be particularly cautious about instrumental connections, particularly if we only look at litigation. It seems that actually in quite a few countries, right to water litigation per se isn't where it's happening. It's maybe happening along administrative or environmental justice, etc., different lines. But that's not to say that the rights are not being used and mobilized. And I think it's very interesting using the US example, because activists and how rights are used as part of a power discourse and changing the domain of power and leverage politically. And you see that very much in the US in cities like Flint and Detroit, where despite the fact there is no right to water recognized in the US, activists have mobilized very much along a right to water. And this has given them a lot of momentum and catalyzed action. So I think these are very important dimensions to also pursue.
There's a question for Rebecca. Rebecca, shall I read it out? In the United States, if a family or individual cannot afford to pay the water bill or satisfy their basic needs of drinking water, can they use a legal tool? For it? Is the municipal government, owner or supervisor of the water company, obliged to guarantee access to water?
So certainly this varies by city, by state, by town. There's a lot of variation here. I was a social worker with the state of Massachusetts prior to getting my PhD. And I know that in Massachusetts, there are, like, the first step would be applying for some sort of community or government assistance. While I know that in much colder places than where I am currently located in Florida, it's illegal to turn off heat and things like that for issues of safety. It is not illegal to turn off water. Again, this varies a lot. So I would say there's probably some states where it is illegal to turn off a family's water. But I think that rather than, trying to mobilize some sort of right, instead, this would be about, litigation. You would be suing a water company for not providing, like in Flint, you're trying to sue a water company for not providing safe water. And after that, you would probably go through some sort of social safety mechanism, right? Like applying for a loan or applying for some sort of forbearance to have your water kept on, or welfare or something like that. So yeah, I think it varies pretty widely. And I think that outside of like specific situations, you probably aren't trying to mobilize, trying to utilize a right to get your water to be kept on.
It's it's sometimes it's sometimes when we when from India, when we hear about these cases, you feel like, don't they have local politicians? Don't they have ward councillors? But I mean, I understand that there are things we take for granted in a in a more porous and weak state where there are confusion, there are confusions and therefore multiple versions of how water, there are multiple versions of rights, but there are also, in parallel, we have multiple versions of how water is governed by the same water providing agency. And in those, in the field of urban studies, there's a lot of scholarship that's, pointed out that these multiple versions are useful sometimes, to some people and in some places. It's not to glorify confusion, but to say that in an imperfect world there are different types of imperfections. Namita, I think a quick closing point. We're out of time now, so we'll close after that.
Yeah, sure. I just wanted to sort of take an example from the pandemic to kind of illustrate the kind of discussion we've been having. We are in a situation where it is in our best interests of everyone in the world that everyone should get vaccinated, right? Because that's the one way to build herd immunity. And the pandemic has really shown that we're all connected and we can't keep away from each other, etc. And yet what we find is that the rich countries have bought up the vaccines. I mean, the US has bought up a huge share of the vaccines, and many countries are just not able to vaccinate their population. And I think that if this were, because it is left to the sort of national framework and so on. So in other words, if there was an internationally recognized obligation that each person must be vaccinated, and that's where I think, even though we have I have spoken about the national framing of the right to water and the fact that it's different in different contexts. I just wanted to end with that, because I think where the international becomes important is in situations like this. We can envisage a situation in case of transboundary water disputes and so on. We have that with interstate river disputes in India, where one state is trying to claim water for its population, another state is not. And I think that's where the international recognition of the right to water of every individual matters, because even at the level of the national, we have these kinds of disparities and the inability for the governance framework and the development frameworks to provide for everyone. I think that's where the rights discourse does matter, with all its imperfections. And I think, as Arkaja said, the more imperfect the system is, the opportunity structures are greater in your ability to mobilize it. And yeah, of course, rights can be mobilized at all levels, not just bureaucracy and courts. Like I said, there is an affirming moral language, a protest that Jackie spoke about, just protesting outside and picketing a private water company and, forcing them to come to the negotiating table is part of the articulation of that right. And I think that is something that is important from a dignitarian point of view for each individual.
Thank you guys for for an excellent discussion, and for the interconnectedness and the many different kinds of many different sort of threads and many different energies that come to the discourse of rights from different types of contestations, the interconnectedness of rights and claims over natural resources, and different types of claims that people could make on water as service, as a resource, as infrastructure, and as part of a democratic process. Thank you guys, and I think at this moment we can close, and we have a little visitor, so I think this is the time to close this discussion. Thank you guys.